Alternatives to litigation. As you know by now, litigation is very involved. There are a lot of steps. It's a long process. One thing we haven't talked about is the fact that litigation is not only time-consuming, but very expensive. For instance, in personal injury cases, like the bicycle case of Miss Winters versus Mr. Ramirez, if that personal injury case was taken on a contingency, which many are, that means that the plaintiff got an attorney and she agreed to a contingency arrangement or contingency fee with the attorney, whereby the attorney works for free until and unless the attorney is able to secure some sort of settlement or wins a case for the plaintiff. In other words, the plaintiff's attorney does not get paid until and unless the defendant settles with the plaintiff or the plaintiff wins her case. And there is no way of knowing or predicting how long that might take. The plaintiff, therefore, wants this case to move quickly so that there can be a resolution. Why would a plaintiff's attorney agree to do this, essentially working free until and unless they win the case? Because their contingency fee is a significant part of any settlement that you receive. Typically, it can run from anywhere from 25 to 40% of whatever you recover. So for instance, if you are a plaintiff and you win a $100,000 judgment, your attorney might, typically take $30,000 of that. That's 30%. Now, a lot of times people gawk at that. I'm like, oh my gosh, they're taking so much. But can you imagine working for someone for free and not knowing how long you might be working for them for free and not knowing whether or not you actually are going to win the case and receive any money for them? So plaintiff attorneys who work on contingency are actually one, they're very entrepreneurial generally. Two, they're doing a service because they enable the public to pursue cases that they might not be able to afford otherwise. And three, I would have to say they've got a high risk tolerance in the sense that they are willing to deal with this ambiguity of not knowing how long it will take until they're paid, which is also why most plaintiffs' attorneys who do work on contingency have hundreds, if not thousands, of cases because they need to have lots going at once to keep cash flow coming in to keep themselves afloat. In contrast, defense attorneys, we are paid hourly from the time that we are retained to represent you. So I'm going to be paid whether or not you win or lose, and no matter how long it takes. Yes, that can be quite expensive. You have to pay your defense attorney even if you are not liable, even if you're not guilty. Even if you're found innocent in the criminal context, and even if you're found not liable in the civil context, if you are the defendant, you're going to be paying a legal bill. So that is expensive, and it also is an incentive for the client to also want to see a resolution sooner rather than later because they are paying their attorney no matter what. So that's why it would make a lot of sense to look at alternatives. There are lots of alternatives to litigation listed in your textbook, but there are only two, and these are the two main ones that I'm interested in making sure that you all know. And so we're going to look at mediation and arbitration here in a second, but I will say, even though I just said that there are two, you could almost argue that there are three. So I'm going to back up. I mentioned earlier settlement, and that settlement often occurs after the discovery phase or at the completion of the discovery phase. Settlement, so we can call this actually our third way of resolving a case without going to trial. Settlement is available to the parties at any time. A settlement is a situation where the plaintiff's attorney and the defendant's attorney, they call one another up and they say, look, this is costing a lot of money. This is taking a lot of time. You see that I've got a strong case. We've gone through the depositions. You heard the evidence. Why don't you make my client an offer? That's the plaintiff, right? Or if I'm the defendant, look, I took your client's deposition. Their medical records aren't that strong. It's clear that my client was abiding by the speed limit and had the right of way. I'll offer you $2,000 so that we can end this. So that could happen literally at any point of the litigation. It could happen after you receive the complaint before you file an answer. I have made offers to settle cases before filing an answer. Now, is the attorney doing that? The attorney is the one who offers it, but it's with the consultation of your client. So my client, if I'm making an offer to settle that early, it's because my client has told me I don't want to spend a lot of money. I want this to go away. So remember, even though I will say and I'll speak as if attorneys are making the decisions, we represent our clients, and our clients ultimately are the ones who have to make the decision. Particularly if you're the defense, it's the client who's going to be paying the money, not the attorney. So, which is also why sometimes your client may not want to settle for the amount that you, the attorney, advise them for. Sometimes your client doesn't agree with your assessment of how weak their case is or how strong, but usually it's when you're telling them the case is weak that they don't really agree. But so you're always doing this at the pleasure of your client, but you can offer to settle either side at any time. Now, realistically, it's usually going to be the defendant who is advancing settlement. But plaintiffs will also send defense attorneys, they'll send us letters letting us know, this can go away if you're willing to pay X amount of dollars. So I have received cases where the plaintiff's attorney sent me a copy of a complaint that they have not filed yet with the court. It's the draft. So they'll send me a letter with a draft complaint attached and say, hey, I'm going to file this complaint next week with the Superior Court unless your client would be willing to pay $3,000 today. And they wouldn't literally say today, but now. And so that's sort of a veiled threat. In other words, we're going to file this lawsuit unless you give us some money. I'll say that has never worked. I have never had a client who was like, yeah, go ahead and pay them. And I haven't had a case where I thought it was a slam dunk that we needed to go ahead and pay them. But I have received that many times from a plaintiff. So that's really their way of trying to settle the case very early. And either party can initiate that at any time. Now, mediation is more formal. Mediation is oftentimes court ordered. And in North Carolina, all cases must go to court ordered mediation before they'll get a trial date. Our courts, our state courts, want us to settle if we can. Why? Because they're overcrowded. Remember when we looked at subject matter jurisdiction for courts? They get everything that doesn't fit into the federal court system. So there are tons, hundreds, actually there may be some court systems, some states, thousands of cases pending. So as many as they can encourage to settle before heading to trial as possible, the courts are going to encourage that. So every case in North Carolina is referred to court-ordered mediation before getting a trial date. When you have mediation, the parties agree upon a mediator who is literally going to come in and help you settle the case. They're going to be like the middleman. They're going to facilitate. They're going to be the third party who goes between each side, listens to your evidence and your argument. You'll put on like a little mini oral argument for the mediator, and the mediator hears each side, and then you break out. So when you do your little short oral argument, all sides, because it can be more than two parties in a lawsuit. So all sides are in the same room because you want everybody to hear it. Because sometimes plaintiffs believe that their case is stronger than it really is. And then when they hear the defendant's attorney give their preview of their case, they're like, wow, okay, yeah, I wasn't expecting that. And so then it changes their mind, even though their attorney might have been telling them all along that their case wasn't as strong as they thought. Sometimes people are stubborn and they believe their attorneys just don't want to be bothered or don't want to proceed with their case. And sometimes people think their lawyers, may not know what they're talking about. But then when they hear the other side's view of the case, it helps people to realize and see their case more clearly. So after the short oral arguments, then each side goes to a separate room and the mediator comes and meets with you individually, each side individually, and they will help to point out to you what your weaknesses are. Most good mediators, they'll start off with telling you, yeah, I see what you're saying. Yeah, you had good points here, but did you think about X? And did you hear when they said Y? And they start talking to you about all the ways in which you could lose. And they do that for both sides. Why? Because they're trying to get us to meet in the middle and to impress upon us the fact that you all have something to lose, that going forward with the trial is going to be costly and expensive and time consuming for all involved. Can't we come to some sort of compromise? And the thing about mediation is typically nobody leaves with what they wanted. It's not a leave and I'm so happy. The defendant is going to end up paying maybe more than they hoped, and the plaintiff is going to end up getting something, but probably less than they wanted. That's a good mediation. In contrast, in arbitration, arbitration is also more formal, and a lot of times this is a way of resolving a lawsuit that parties agree to beforehand by putting it in their contract. A lot of commercial contracts and construction contracts have in them clauses that if there's a dispute, it will go to arbitration rather than trial. And in arbitration, sometimes you have a single arbitrator or sometimes you have a panel of three. And the arbitrator acts very much like a judge in the sense that they are going to take evidence from the parties and they're going to look at the evidence. And this is more formal than when the mediator was talking. They weren't looking at our evidence, they just heard our arguments. With arbitration, the arbitrator actually is going to receive evidence and review it and make a reasoned decision based upon their review of the evidence. So it's more like it's kind of like a hearing or a junior trial. I'm just going to make that term up. And depending upon why you're in the arbitration, whether or not you have put it in your contract or not, will affect whether or not the decision of the arbitrator is binding. If you put it in your contract that this decision of arbitration would be binding, then it will be. You can still, sometimes people still appeal to courts, but the court is going to look at what you put in your contract. So that is the difference. Arbitration is much more formal, and you've got, a more formal review of evidence and a written decision. Mediations are, you're getting together, you've got a mediator, and the mediators are usually lawyers or retired judges. So it's informal. We just kind of give a preview of what our case would sound like, and we just try to negotiate. And then the third one that I mentioned, settlement, is just like mediation, but it's done by the parties themselves without a third party intermediary. So if you are looking at a scale, settlement is the easiest, fastest to do with no outside parties. It's just the parties' attorneys working on it, right? So we could put that on the left as easiest, cost-effective, little time. Then mediation, a little more formal. You have a third party who's supposed to be neutral, who helps bring the parties together. Arbitration is more formal, put that far on the right, but it's also a separate entity that typically the parties had to have agreed to, usually by contract. So these are the three methods I would expect you to understand and be responsible for if you're thinking about what could I do other than going to trial. And also, please notice the Padlet assignment here, and I would like you to go in and think about if you had a dispute. Would you choose to litigate or would you mediate?